Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Every case is unique, and family law varies significantly across different state jurisdictions and over time. We are not attorneys, and the historical trends and case studies discussed here should not be used as a substitute for the counsel of a licensed professional in your specific area. You should always conduct your own due diligence and seek expert guidance before making any decisions regarding your domestic or financial affairs. There is a staggering number that defines the lives of millions of American men today. $114 billion. That is the estimated amount of cumulative child support debt currently owed in the United States. For many divorced fathers, this number is not just a statistic. It represents a complex, often adversarial relationship with a system that seems to view them more as a ledger entry than a parent. But to understand why the modern system operates with such clinical, often cold efficiency, we have to look past the modern courtroom and into a history that most people have completely forgotten. Imagine a world where, for centuries, the very idea of a father being ordered by the state to pay for his child was legally non-existent. Then, imagine a sudden, radical shift in the 19th century that stripped fathers of their historical rights, while simultaneously cementing their financial obligations in stone. This is not just a story about money. It is a story about how the American government fundamentally redefined the definition of fatherhood. In this deep dive masterclass, we are going to peel back the layers of the American child support system. We are going to solve the mystery of why the system feels rigged against the modern dad, by tracing its evolution from colonial property law to the high-stakes federal enforcement machine of the 21st century. By the end of this series, you will understand the historical trends that led to the current best interests of the child standard and the specific legislative turning points that transformed divorced fathers from heads of household into obligors. If you have ever felt like a visitor in your child's life while being a full-time provider to the state's enforcement agencies, this deep dive is designed for you. To truly understand the modern divorced father's experience, we have to start at the very beginning, in the colonial era and the roots of English common law. In the 1700s and early 1800s, child support as we know it today did not exist. Under the legal doctrine of coverture, a woman's legal identity was merged into her husband's. This meant that the father was the absolute head of the household, but it also meant he had absolute custody rights. If a marriage dissolved, which was rare and socially taboo, the children almost always stayed with the father. The logic was simple, if harsh. The father owned the land, the father provided the protection, and therefore the children were considered his legal responsibility and in some ways his property. Because he had the children, there was no need for a support payment to another household. However, as the Industrial Revolution began to tear at the fabric of agrarian society, the traditional family structure began to fracture. Men were no longer working on the family farm. They were heading into the factories of the burgeoning American cities. This physical separation of the father from the home created the first major shift in parental roles. As fathers became the breadwinners and mothers became the nurturers, the legal system began to take notice. This led to the emergence of the tender years doctrine. First established in the British Talfords Act of 1839 and quickly adopted by American courts, the tender years doctrine suggested that during a child's early years, usually up to age 7, the mother was the more suitable parent due to her natural nurturing instincts. This was a massive historical pivot. For the first time, fathers were losing their automatic right to custody. But here was the catch. While the courts began to favor mothers for physical custody, they maintained that the father was still the primary source of economic stability. This created the fundamental disconnect that many divorced dads feel today: the separation of parental rights from parental obligations. The father was now expected to provide the financial means for a household he no longer lived in, and for children he no longer raised on a daily basis. As we move into the early 20th century, the pressure on the state to manage these growing family fractures increased. By 1910, the National Conference of Commissioners on Uniform State Laws drafted the Uniform Desertion and Non-Support Act. This was a watershed moment. It didn't just suggest that fathers should pay. It made it a criminal offense for a man to desert or fail to support his wife and children in destitute or necessitous circumstances. We see here the first real teeth of the enforcement system. At this time, the focus was primarily on preventing families from becoming a burden on the public purse. If a father left and the mother and children were forced to rely on local charities or the town's poorhouse, the state saw that as a direct financial loss. This brings us to one of the most significant dates in this historical deep dive: 1935. This was the year the Social Security Act was passed during the height of the Great Depression. Within this massive piece of legislation was Title IV, which created the Aid to Dependent Children program, later known as AFDC. Originally, this was intended to help widows, women whose husbands had died and left them with no means of support. However, as the decades rolled on, the demographics of those seeking aid shifted from widows to divorced or never married mothers. This shift changed the government's role from a temporary safety net into a permanent collection agency. The government realized that every dollar paid out in welfare to a single mother was a dollar that could potentially be recovered from the child's father. This birthed the modern era of Title IV-D. By the mid-1970s, the federal government became the primary driver of child support enforcement. This wasn't just about the well-being of the child. It was a fiscal strategy to minimize government spending. If the state could aggressively pursue obligors, it could offset the cost of public assistance. This historical trend is vital to understanding the Title IV-D agencies that many dads deal with today. These agencies are often incentivized by federal funding to collect as much as possible, regardless of the individual nuances of a father's financial or emotional situation. Consider the case of the man-in-the-house rules during the mid-20th century. In many states, if a mother was receiving government aid, she was strictly forbidden from having a man, including the biological father, living in the house. If a father tried to be present, the family could lose their financial lifeline. This created a perverse incentive that actively pushed fathers out of the home, further cementing the visitor-payer dynamic. The law was effectively telling the father, "You can be a provider through the state's ledger, but you cannot be a presence in the home without jeopardizing your children's survival." As we examine these historical trends, we see a clear pattern emerging. The system was not designed with the emotional bond between father and child as its primary priority. It was designed to manage the economic fallout of family dissolution. In the 1980s and 90s, this reached a fever pitch with the deadbeat dad narrative that dominated the media and political landscape. This era saw the introduction of license revocations, passport denials, and even incarceration as standard tools for collection. While these measures were aimed at those who willfully avoided their responsibilities, they often caught up well-meaning fathers who had simply fallen on hard times, creating a cycle of debt and legal entanglements that became nearly impossible to escape. To understand your position today, you must realize that you are operating within a framework that has been building for over 150 years. A framework that was built on the assumption that a father's value is primarily measured in currency. By looking at these case studies from the past, we start to see that the frustrations of the modern divorced dad aren't just personal grievances. They are the result of a long documented history of legal and social engineering that we are only just beginning to unpack. To understand why the modern landscape of fatherhood feels so precarious for many, we have to look at the massive legislative shift that occurred in 1975. This was the year the federal government decided to get into the business of family management in a way that had never been seen in American history. When Congress passed the Social Security Amendments of 1974, which created Title IV-D of the Social Security Act, they weren't just creating a new department. They were building a multi-billion-dollar infrastructure that would eventually influence the lives of every divorced father in the country. Imagine if you are a father named David living in the year 2026. You sit down to look at your digital paycheck, and you see a deduction for child support that was calculated using a formula designed in an era long before your children were even born. To understand that deduction, David needs to understand the 1975 pivot. Before 1975, child support was largely a local, civil matter handled by county courts with a high degree of judicial discretion. A judge would look at a father, look at a mother, and try to determine what was fair based on the father's actual ability to pay. But the 1974 Act changed the objective from fairness to fiscal recovery. The federal government was concerned about the rising costs of the Aid to Families with Dependent Children program. They realized that if they could force biological fathers to pay more, the state would have to pay less in welfare. To ensure this happened, the federal government offered the states a deal they couldn't refuse. Under Title IV-D, the federal government agreed to pay for 66% of the costs of running a state's child support enforcement program. This created a massive financial incentive for states to create aggressive, high-volume collection agencies. But it didn't stop at just covering costs. The federal government also began providing incentive payments to states based on their performance. The more money a state collected from fathers like David, the more federal bonus money that state received. This historical trend effectively turned the child support system into a revenue-generating machine for state bureaucracies. By the time we reached the mid-1980s, the system was no longer just about the children, it was about the survival of the state's budget. In 1984, the federal government doubled down with the Child Support Enforcement Amendments. This legislation mandated that states implement laws requiring income withholding for all child support orders. Before this, you usually had to be behind on payments before your wages were garnished. After 1984, the system began treating every father as a potential flight risk. For David in 2026, this means his employer is legally required to act as an agent of the state, removing funds from his check before he even sees them. This shift fundamentally changed the relationship between the father and his employer, adding a layer of social stigma that many men still struggle with today. Then came 1986, and with it, perhaps the most controversial piece of legislation in the history of American family law, the Bradley Amendment. Imagine if David loses his job in a 2026 economic downturn. Under the Bradley Amendment, child support debt is considered a non-dischargeable debt that cannot be retroactively modified. If David takes 3 months to find a new job and get a court date to lower his payments, those 3 months of high-level payments are locked in forever. The court literally lacks the legal authority to forgive that debt, even if David was physically unable to pay. This created a scenario where a father could fall into a hole of debt that is mathematically impossible to climb out of, leading to what many researchers call the debtor's prison effect, where men are incarcerated for civil contempt because they cannot pay a debt that the law refuses to adjust. By 1988, the Family Support Act took things a step further by requiring all states to adopt numerical guidelines for setting child support amounts. Before this, judges had the flexibility to consider a father's unique expenses. Perhaps he was caring for an elderly parent or had high medical bills of his own. The 1988 Act replaced that human element with a mathematical formula. Most states adopted either the income shares model or the percentage of income model. For David, this means his support is calculated based on a rigid chart. If the chart says he owes 25% of his gross income, he owes 25%, regardless of whether that leaves him enough to afford a home where his children can actually come to visit. These historical trends were fueled by the deadbeat dad narrative of the 1990s. This was a high-stakes political era where both parties competed to see who could be tougher on non-custodial parents. This led to the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. This law linked child support enforcement to a father's very identity. It mandated that states implement systems to revoke driver's licenses, professional licenses, and even passports for those who fell behind. Imagine David in 2026, a contractor who needs his truck and his license to work. If he falls behind on his payments due to the rigid formulas in the Bradley Amendment, the state can take away his ability to drive to the job site. It is a logical paradox. The state takes away his means of making money because he isn't making enough money. The 1996 Act also created the National Directory of New Hires. This was a massive federal database that tracked every person who started a new job anywhere in the United States. This allowed the Title IV agencies to track fathers across state lines with military precision. While this was framed as a way to ensure children were provided for, the data shows a more complex outcome. For many fathers, this level of surveillance and the immediate garnishment of wages regardless of their current living situation led to a retreat into the informal economy. They started working for cash not to avoid their children, but to avoid a system that they felt left them with nothing to live on. Step by step, the American legal system moved from a model of what does this family need to how much can we extract to offset state costs. This transition has had a profound impact on the psychology of the American father. In 2026, men like David are often told that the system is gender neutral, but the historical weight of these laws tells a different story. The infrastructure was built during a time when women were rarely the primary breadwinners, and the laws have been slow to adapt to a world where many fathers want to be equal, hands-on parents rather than just sources of revenue. Data from the late 2010s and leading into the 2020s shows that when child support orders are set too high, specifically above 15 to 20% of a father's gross income, compliance rates actually drop. This isn't because fathers don't want to pay, it is because they physically cannot survive while doing so. Yet, because of the historical legacy of the 1988 guidelines and the 1986 Bradley Amendment, the system often remains inflexible. We are looking at a machine that was built to be efficient, but in its efficiency, it often grinds up the very people it was supposed to regulate. But what happens when this mechanical system is faced with a father who doesn't just want to pay, but wants to stay? What happens when the financial extraction model hits the wall of modern shared parenting? In the next part, we are going to dive into the custody support linkage and look at the shocking way that money and time were legally tied together, often creating a pay-to-play barrier that keeps fathers away from their children's bedside. We will explore the secret math behind the visitation credit and why some states are fighting to keep fathers out of the home to keep the federal funding flowing. You won't want to miss the hidden reality of how your time with your children is being appraised by a 50-year-old bureaucratic formula. The separation of parenting time and child support is one of the most jarring legal realities a father faces in the American family court system. To see this in action, imagine a man named Marcus in the year 2026. Marcus is a dedicated father who has been paying his court-ordered child support faithfully every month. However, for the last 3 months, his ex-spouse has denied him his scheduled weekend visits, citing various excuses from illness to sudden out-of-town trips. Marcus goes to the local enforcement agency, thinking that because he is fulfilling his financial obligation, the state will enforce his right to see his children. Instead, he is met with a cold legal truth. In the eyes of the law, child support and visitation are two entirely separate silos. This is known as the doctrine of non-interdependence. Historical trends show that this doctrine was established to ensure that children were not used as pawns in financial disputes, but in practice, it often leaves fathers like Marcus in a vulnerable position. The law dictates that a father cannot withhold support if he is denied access, yet the mechanisms to enforce visitation are often significantly weaker and more expensive than the mechanisms used to collect money. If Marcus stops paying, the state's Title 4D agency will automatically trigger wage garnishment or license suspension. If Marcus is denied his children, he must hire a private attorney, file a motion for contempt, and wait months for a hearing. This creates a pay-to-play environment where the father's financial contribution is guaranteed by the state, but his physical presence is treated as a secondary, private matter. To understand why this imbalance exists, we have to look at how the system mathematically appraises a father's time. In 2026, most states utilize a version of the income shares model, which includes a visitation credit or a parenting time offset. This is a step-by-step calculation that adjusts the amount of child support based on the number of overnights a child spends with each parent. For example, in many jurisdictions, there is a specific threshold, often around 128 overnights per year, where the child support amount drops significantly once a father crosses from standard visitation into shared custody. Imagine the impact of this threshold on a high-conflict divorce. If a father reaches that 128th overnight, the monthly support payment might drop from $1,200 to $400. This $800 difference creates a massive financial incentive for the custodial parent to gatekeep and prevent the father from reaching that magical number. The historical trend in the United States has been to treat child support as a replacement for the father's presence, rather than a supplement to it. When the system attaches a high dollar value to every overnight stay, it inadvertently turns the children into a commodity. The courtrooms of 2026 are still filled with parents fighting over a single Tuesday night, not because of the child's schedule, but because that Tuesday night represents a shift in the financial ledger. Case studies from states that have moved toward a rebuttable presumption of 50-50 shared parenting, such as Kentucky or Arizona, offer a fascinating look at how this dynamic changes. In these states, the starting point is equal time. When the time is equalized, the child support amounts often decrease because the father is directly providing for the child's needs, housing, food, and utilities, during his half of the time. However, this shift toward shared parenting has historically met significant resistance from state bureaucracies. This brings us to the hidden conflict of interest within the Title 4D system. As we explored previously, states receive federal incentive payments based on the total amount of child support they collect. If more fathers are granted 50-50 custody, the total amount of child support ordered across the state will naturally decline. For the state's child support agency, a decline in orders means a decline in their collection metrics, which can lead to a reduction in federal funding. This creates a systemic bias toward the status quo of primary and non-custodial roles. The state has a literal, documented financial interest in ensuring that one parent remains the primary collector and the other remains the primary payer. Step by step, the process for a father like Marcus to increase his time is often blocked by these fiscal realities. If he moves for 50-50 custody, he is not just fighting his ex-spouse, He is fighting a historical legal framework designed to maximize the flow of capital through state accounts. In the year 2026, the data shows that children with active, involved fathers have better outcomes in education, mental health, and social stability. Yet, the child support formula remains largely indifferent to these qualitative outcomes, focusing instead on the quantitative extraction of funds. Consider the secondary parent syndrome that this creates. When the law defines a father primarily as an obligor, it diminishes his role to that of an ATM. Historical trends in family psychology suggest that when men feel their only value to their children is financial, they are more likely to experience parental burnout, or eventually withdraw from the conflict altogether. This withdrawal is often misinterpreted as a lack of interest, when in reality, it is a response to a system that makes every hour of parenting a legal and financial battle. In 2026, we see the emergence of child support cliffs. These are points in the guideline formulas where an increase in a father's income, even a small one, can trigger a disproportionately large increase in support, effectively taxing his extra effort at a rate higher than any federal income tax bracket. If Marcus takes a promotion to better provide for his future, the formula may take 40% of that raise in increased support, while his time with his kids remains capped. He is working more hours to pay for a life he isn't allowed to fully participate in. This deep dive into the custody support linkage reveals that the modern father is often trapped in a 20th century economic model that hasn't kept pace with 21st century social values. We are living in an era where fathers want to be present for the homework, the doctor's visits, and the mundane daily routines. But the system was built on the tender years legacy, which assumes the mother provides the care and the father provides the cash. When these two roles are forced into a single mathematical equation, the result is often a loss of parental rights under the guise of financial responsibility. To navigate this, one must look at the specific case studies of fathers who have successfully challenged the visitor status. These fathers often have to prove that they are more than just a paycheck, documenting every minute of involvement to overcome the state's financial preference for a primary custodial parent. But even with documentation, the Bradley Amendment and the non-interdependence doctrine stand as formidable barriers. What happens when the money simply runs out? What happens when a father, despite his best efforts, falls into the trap of imputed income, where the state charges him based on what they think he should be making, rather than what he actually earns? In the next part, we are going to explore the dangerous world of imputed income and the phantom debt. We will look at how the government uses historical earning data to create debt out of thin air, and how this phantom debt leads to the most controversial aspect of the child support system: the modern-day debtor's prison. We will break down the Supreme Court cases that were supposed to stop this, and why, in 2026, men are still being locked up for being poor. The reality of contempt of court is much darker than you've been told, and it's the next stop in our masterclass. To truly understand the modern-day mechanics of the child support system, we must examine a legal concept that sounds reasonable in theory, but has become a primary driver of financial ruin in practice: imputed income. Imagine a father in the year 2026 named James. James was a software engineer earning $160,000 a year. During a major industry shift driven by artificial intelligence, his entire department was liquidated. James, despite his best efforts, could only find a role in a local logistics firm earning $55,000 a year. When James goes to court to modify his child support order to reflect his new financial reality, he encounters the ghost of his former self. The court looks at his historical trends and decides that because he has the education and the experience to earn $160,000, he is voluntarily underemployed. The judge then imputes his income at the higher level, meaning the court orders James to pay child support as if he were still making six figures, even though his actual bank account says otherwise. This is the birth of what we call phantom debt. Imputed income is based on a father's capacity to earn rather than his actual earnings. Step by step, here is how this process creates a mathematical death spiral. If the court determines James should be making $160,000, they might set his support at $2,000 a month. But James only brings home $3,200 a month in his new job. After paying the $2,000 in support, he is left with $1,200 for rent, food, utilities, and gas in the year 2026. If he cannot survive on that amount and fails to pay the full $2,000, the difference is added to his arrears. In many states, this debt is then hit with high interest rates, sometimes as high as 10 or 12% annually. This is not just a debt, It is a predatory financial instrument enforced by the power of the state. The historical trend of imputing income began as a way to prevent wealthy individuals from hiding assets or intentionally quitting high-paying jobs to avoid their responsibilities. However, case studies from the last 2 decades show that the vast majority of those hit with imputed income are not wealthy tax evaders, but low-income or middle-class men caught in economic transitions. For James, the debt grows month after month. Because of the Bradley Amendment, which we discussed earlier, this debt cannot be retroactively reduced. Even if James eventually finds a high-paying job 2 years later, he is still legally obligated to pay every cent of the debt accrued during his unemployment, plus the compounded interest. This brings us to the most heavy-handed tool of the system: civil contempt of court. In the United States, we officially abolished debtors' prisons in the 19th century. You cannot be jailed for failing to pay a credit card or a car loan. However, child support is classified differently. Because it is a court order, failure to pay is treated as a direct challenge to the authority of the judge. This is where the story of James takes a dark turn. When James falls $5,000 behind because his imputed income is higher than his actual income, he is summoned to a contempt hearing. In a standard criminal case, you are entitled to a lawyer, and the state must prove you are guilty beyond a reasonable doubt. But in a civil contempt hearing for child support, the burden of proof often shifts. James must prove that he has the inability to pay. If he cannot provide a paper trail that satisfies the court's narrow definition of hardship, the judge can issue a purge order. This is a specific dollar amount that James must pay immediately to stay out of jail. If the purge is set at $3,000 and James only has $400 in his pocket, he is taken into custody. We must look at the landmark Supreme Court case of Turner v. Rogers from 2011. This was supposed to be the case that ended the modern debtor's prison. The Supreme Court ruled that a state could not jail an indigent parent for civil contempt without either providing a lawyer or ensuring a highly robust process to determine if the parent actually had the ability to pay. The court recognized that jailing someone who literally has no money serves no purpose other than punishment. However, the implementation of Turner v. Rogers in 2026 remains deeply flawed. Many jurisdictions bypass the spirit of the ruling by continuing to use imputed income. The court argues that since James has the capacity to earn more, his failure to pay is willful, and therefore, he does not count as indigent. Imagine the logic of the situation James finds himself in. He is in jail because he didn't pay money he doesn't have. While he is in jail, he loses his $55,000 job. While he is in jail, his child support debt continues to grow every single month because the Bradley Amendment prevents the clock from stopping. When he is eventually released, he has more debt, no job, and now a criminal record or a history of incarceration that makes it even harder to find a high-paying role. This is the definition of a systemic trap. Data from state-level audits consistently shows that the majority of child support arrears are owed by men who earn less than $10,000 a year. These are not deadbeats in the traditional sense. They are people who are fundamentally disconnected from the economy, yet the system treats them as if they are simply being stubborn. In the year 2026, the use of automated license plate readers and advanced data tracking makes it easier than ever for the state to find James and put him back in a cell. But it does nothing to help him find the employment he needs to settle the debt. The reason this system persists, despite its clear logical failings, returns to the Title IV defunding model. When James is in jail, he is counted in the state's enforcement statistics. When a state secures a purge payment, perhaps from James's aging parents who raid their retirement savings to keep their son out of a cell, that payment is recorded as a collection that triggers federal incentive bonuses. The system is incentivized to squeeze the debt out of any available source, even if it destroys the father's long-term stability and his relationship with his children. Step by step, the child support system has evolved from a social safety net into a high-stakes collection agency that utilizes the threat of incarceration to enforce mathematical formulas that often bear no resemblance to reality. For James, the psychological toll is immense. He feels like a fugitive in his own country, constantly looking over his shoulder, knowing that a single traffic stop could lead to months behind bars because of a phantom salary the court decided he should be making. This leads us to a critical question that most people are afraid to ask. If the system is so focused on the best interests of the child, why does it prioritize the collection of debt over the presence of a father? Why is a father in a jail cell considered a better outcome for a child than a father working a lower-paying job and being present in that child's life? In the next part of our deep dive, We are going to look at the hidden beneficiaries of this system. We are going to explore the multi-billion-dollar fatherhood industry, including the private companies that manage state collection databases and the lawyers who profit from the high-conflict litigation that the system encourages. We will uncover how the 2026 technological landscape has allowed private corporations to profit from every dollar garnished from a father's paycheck. You will see how the business of child support has outpaced the morality of it, and we will reveal the specific lobby groups that fight against any reform that would make the system more flexible. The paper trail of your child support dollars goes much further than your ex-spouse's bank account, and the next part will show you exactly where it ends up. To follow the money in the American child support system, we have to look past the individual parties and toward the sprawling corporate infrastructure that facilitates every transaction. Imagine a father in the year 2026 named Robert. Robert is a middle manager who has his child support payments automatically deducted from his paycheck via a digital wage assignment. On the surface, it looks like a simple transfer from Robert's employer to his ex-spouse's bank account. However, beneath that digital interface lies a multi-billion-dollar industry composed of private contractors, software vendors, and financial intermediaries who have turned the enforcement of child support into a high-margin business. The first major player in this fatherhood industry is the private contractor. Since the 1990s, many states have moved to privatize the day-to-day operations of their Title 4D offices. Companies like Maximus and Conduent have secured massive contracts to handle everything from locating non-custodial parents to processing payments and answering customer service calls. In the year 2026, these companies operate with the efficiency of a high-tech logistics firm. They are not government agencies. They are publicly traded corporations or large private entities with a primary obligation to their shareholders. Step by step, let's look at how a single payment from Robert is processed. When the money leaves his employer's payroll system, it first hits the State Disbursement Unit, or SDU. In most states, the SDU is managed by a private vendor. For every transaction processed, that vendor often receives a fee. While a few cents per transaction may seem negligible, when multiplied by the millions of children in the system and the frequency of biweekly paychecks, these processing fees generate hundreds of millions of dollars in revenue. This is a historical trend where the state effectively outsources its police power to the private sector, creating a scenario where the enforcement of family law is tied to corporate profit margins. But the revenue doesn't stop at transaction fees. In 2026, the technology used to track fathers like Robert has become incredibly sophisticated. Private data mining firms now sell real-time access to employment records, bank account balances, and even geolocation data from connected vehicles. These companies provide the digital leash that allows the state to maintain near-constant surveillance on a father's financial health. If Robert receives a small bonus or a cost-of-living adjustment, the software flags it immediately. The state then pays a subscription fee to these tech providers for the privilege of using this data. This creates a circular economy where the state uses taxpayer money to buy data from private companies to extract more money from fathers, which in turn justifies more federal incentive payments back to the state. Imagine if Robert's state has implemented a new AI-driven predictive modeling system in 2026. This system analyzes Robert's spending habits and social media presence to estimate his true earning capacity. If the AI decides Robert could be making more money, it triggers an automated review that might lead to the imputed income scenarios we discussed previously. The private firm that developed this AI is incentivized to show results, which usually means identifying more potential revenue. The more aggressive the software is in flagging fathers for higher payments, the more valuable the software becomes to the state agency. This is a classic case study in how algorithmic bias can be baked into a system designed for financial extraction. Another layer of the fatherhood industry is the financial services sector, specifically regarding the disbursement of funds. Many custodial parents receive their support payments on state-issued debit cards. These cards, often branded by major banks, frequently come with a list of fees: ATM withdrawal fees, balance inquiry fees, and even inactivity fees. The banks that issue these cards are part of the hidden beneficiaries of the system. They receive a massive, consistent flow of government-directed capital, and they shave a small percentage off of every dollar intended for the child. For Robert, knowing that a portion of his hard-earned money is going to a bank's quarterly earnings report, rather than his child's education, is a major source of frustration in 2026. We must also address the legal industrial complex. This includes the private attorneys and law firms that specialize in high-conflict custody and support cases. The current system, with its rigid formulas and complex modification procedures, is a goldmine for litigation. If the system were simplified, for example, if child support were automatically adjusted based on tax returns without the need for a court appearance, thousands of lawyers would see their billable hours evaporate. Consequently, there is a powerful lobbying presence that resists any reform aimed at making the system more user-friendly or less adversarial. The historical trend shows that the more complex a law is, the more professional guides are needed to navigate it, and those guides do not work for free. In 2026, we see this lobbying manifest in the opposition to shared parenting legislation. As we noted, 50-50 custody often reduces the total child support ordered. When support orders decrease, the fees collected by processing vendors decrease, the federal incentive payments to the state decrease, and the need for legal battles over every extra hour of visitation decreases. There is a systemic alliance between state bureaucracies, private collection vendors, and the legal profession to maintain the winner-take-all custody model. This model ensures the maximum amount of conflict, which translates to the maximum amount of revenue for the industry. Consider the case study of a proposed reform in a Midwestern state in 2026. The bill aimed to create an administrative modification process where parents could update their support orders online without a judge, provided both parties agreed to the math. This bill was met with fierce opposition not from parents, but from associations representing the private contractors who managed the court's paperwork. They argued that such a system would compromise the integrity of the data. In reality, it would have cut the middleman out of the process, saving fathers like Robert thousands in legal fees, but costing the contractors a lucrative stream of billable services. This leads to a chilling realization. The child support system in the United States has evolved into a self-perpetuating ecosystem. It requires a constant supply of non-custodial parents and arrears to justify its own existence and funding. In 2026, the system is no longer just a way to ensure kids have food and shelter. It is a vital organ of the state's fiscal body, and it is being fed by the labor of millions of men who often feel like they are working for a machine they never asked to build. Step by step, the infrastructure of the system has moved away from human interaction and toward automated enforcement. While automation is framed as a way to reduce bias, it often does the opposite by removing the ability for a father to explain his specific circumstances to a human being with the power to help. In 2026, if the computer says Robert owes money, the computer takes the money. There is no compassion, setting in the software code developed by a private vendor in a distant office park. As we peel back the skin of this corporate monster, we have to ask what this does to the soul of the father. When you are a line item in a private contractor's profit and loss statement, how does that affect your ability to see yourself as a parent? In the next part, we are going to pivot from the bank accounts to the brain. We will dive into the psychological warfare of the system, the visitor status, and the rise of parental alienation. We will explore how the financial pressure we've discussed today is used as a weapon to sever the emotional bond between fathers and their children. You will learn about the erasure effect, and why the system's focus on money often leads to the total psychological displacement of the father. The money trail is only half the story. The emotional toll is where the real damage is done, and that is where we are going next. The emotional displacement of the father begins with a single legal label that carries the weight of a century of bias: the non-custodial parent. In the year 2026, a father named Thomas finds himself living this reality every single day. Thomas is not a visitor in his children's hearts, but according to the state's digital registry, he is exactly that. To understand the psychological warfare embedded in the child support system, we have to look at how the law uses language and scheduling to slowly erode the paternal bond. This is not a sudden break. It is a step-by-step process of marginalization that researchers often call the erasure effect. Imagine if Thomas, in 2026, wants to attend his daughter's parent-teacher conference. Despite having joint legal custody, the school's automated notification system only sends alerts to the primary residential parent. When Thomas shows up, the staff looks at him with a mix of confusion and suspicion, as if his presence is an administrative error. This is a common historical trend in American institutions, where the custodial parent is treated as the default and the non-custodial parent is treated as an optional participant. For Thomas, every interaction with a school, a doctor's office, or a sports league becomes a battle to prove his right to exist in his child's life. Over time, this constant friction creates a psychological wear and tear known as parental burnout. The psychological displacement is codified in the standard possession order, a historical artifact that still dominates many state courts in 2026. This schedule typically grants a father the first, third, and fifth weekends of a month. While this is framed as a way to provide stability for the child, the psychological reality for the father is a state of perpetual mourning. Thomas spends 14 days being a ghost, only to be expected to flip a switch and be a superhero for 48 hours. This Disney dad syndrome is a direct byproduct of the system. Because his time is so limited, Thomas feels pressure to make every moment a high-stakes event, which prevents him from engaging in the mundane, essential acts of parenting, like helping with homework, enforcing bedtimes, or simply sitting in silence. This leads us to the phenomenon of parental gatekeeping and alienation. While these terms are often debated in high-conflict litigation, the historical trends show that the child support system's financial structure actively encourages gatekeeping. When the system attaches a high dollar value to every overnight stay, as we explored in the custody support linkage, it incentivizes the custodial parent to view the father's time as a financial threat. For Thomas, this means that every request for an extra Thursday night is met with a legalistic refusal. The child, observing this conflict, often begins to mirror the custodial parent's anxiety. In 2026, this is further complicated by the use of digital parenting portals. These apps are designed to reduce conflict by documenting all communication between ex-spouses. However, for a father like Thomas, they often feel like a digital panopticon. Every message he sends is archived and can be used against him in a future contempt hearing. If he expresses frustration about missed visitation, it is labeled as aggressive. If he remains silent to avoid conflict, he is labeled as disinterested. This creates a state of hypervigilance. Thomas is no longer just a father. He is a defendant 24/7. The legal system has successfully invaded his private thoughts and his emotional connection to his children. Step by step, the father's role is reduced to what sociologists call the secondary parent syndrome. When the law defines a father primarily by his financial output, the obligor, it sends a powerful message to the child. Your father is a resource, not a relationship. In the year 2026, data suggests that children who grow up in this visitorship model are more likely to experience confusion regarding their own identity and worth. They see their father through the lens of a schedule, rather than a living presence. This is the ultimate cost of the 19th century tender years doctrine that we discussed earlier. It has morphed into a modern psychological barrier that keeps fathers at arm's length. Case studies of fathers who have faced prolonged periods of restricted access show a consistent pattern of depression and identity loss. Thomas may find himself asking, "If I only see my kids 4 days a month, am I still a father?" The system's answer historically has been, "You are a father as long as the check clears." This commodification of parenthood is perhaps the most damaging aspect of the American child support system. It strips away the qualitative value of the father-child bond and replaces it with a quantitative ledger. In 2026, we also see the rise of the self-fulfilling prophecy. When the system treats a father like a flight risk or a secondary actor, he may eventually begin to act like one. The constant legal battles, the financial strain of imputed income, and the emotional pain of being a visitor lead some men to withdraw entirely, a phenomenon sometimes called the ghosting of the American father. This is often misinterpreted by society as a lack of love, when in reality, it is a defense mechanism against a system that has made the cost of staying too high to bear. Consider the psychological impact of the adversarial mirror. In a typical 2026 custody battle, a father is encouraged by his legal counsel to find faults in the mother to justify his need for more time. The mother is encouraged to do the same. This legal requirement to disparage the other parent creates a toxic psychological environment that is the opposite of a healthy co-parenting relationship. The system effectively forces Thomas to burn the very bridges he needs to stay connected to his children. The historical trend has been to prioritize the state's financial recovery over the psychological health of the family unit. By focusing on the collection of support, the system inadvertently devalues the emotional stability that an involved father provides. In the year 2026, as we deal with the national crisis of mental health and social isolation, the exclusion of millions of fathers from the daily lives of their children stands as a massive, self-inflicted wound on the American psyche. Thomas is not alone. There are millions of men in 2026 navigating this same maze of labels, schedules, and digital surveillance. They are the invisible casualties of a system that was designed to manage poverty, but ended up managing human relationships. The erasure effect is real. and it is a documented historical outcome of the laws we have been deconstructing throughout this masterclass. But what happens when this psychological displacement ripples outward? What is the real-world impact on the children who grow up in the shadow of this obligor model? In the next part, we are going to look at the generation of the void. We will examine the shocking data regarding fatherless homes and the specific outcomes for children whose fathers were marginalized by the child support system. We will dive into the longitudinal studies that show exactly what happens to a child's development when the state prioritizes a paycheck over a presence. You will see the direct correlation between the 1975 Title 4D legislation and the social challenges of 2026. The true legacy of this system isn't just found in bank accounts. It is written in the lives of the next generation, and the data is more explosive than you can imagine. To understand the true legacy of the American child support system, we must look at the lives of the children who have grown up within its mechanical embrace. In the year 2026, imagine a young man named Leo. Leo is 19 years old, and he is a second-generation casualty of the 1975 Title 4D legislation. His father was Thomas, the man we discussed in our previous section, who spent 2 decades navigating the visitor-payer model. For Leo, the child support system wasn't just a series of bank transfers. It was the architect of his childhood. To see the impact of this generation of the void, we have to look at the historical trends that correlate the rise of aggressive financial enforcement with the decline of social stability for the American youth. The first step-by-step breakdown of this impact begins with the psychological concept of paternal hunger. Historical trends in developmental psychology show that the presence of a father provides a unique type of emotional regulation and risk-taking guidance that is difficult to replicate. When the state prioritizes the paycheck over the presence, it effectively tells the child that the father's primary utility is his wealth. For Leo, this manifested in a confusing childhood where his father was a recurring guest star rather than a lead character. This creates an attachment injury. Case studies of children in 2026 who grew up under the standard possession order show a significantly higher rate of internalizing behaviors, such as anxiety and low self-esteem, because they subconsciously interpret their father's limited time as a lack of desire rather than a legal constraint. Data from the last 50 years reveals a stark reality. When we look at the social challenges of 2026, including the crisis of adolescent mental health, we find a consistent thread: the marginalization of the father. Longitudinal studies have shown that children from father-absent homes, even when child support is paid in full, are more likely to experience behavioral issues. Specifically, boys are more prone to externalizing behaviors like aggression and poor school performance, while girls are more likely to experience early-onset puberty and higher rates of depression. The system has focused on the financial floor, but in doing so, it has lowered the emotional ceiling for a generation of kids like Leo. Consider the educational impact. In the year 2026, the achievement gap is often discussed in terms of funding, but the historical data points to a different factor: parental involvement. A child with an active father, even one who lives in a separate household, is statistically more likely to graduate from high school and attend college. However, the current child support system creates a logistical nightmare for that involvement. If the father is working extra shifts to meet an imputed income requirement, as we discussed in the case of James, he has no time to help with Leo's science project. If the visitation schedule is rigid, he cannot attend the midweek soccer game. The system forces a choice: be a provider or be a parent. Most fathers try to be both, but the math of the system often makes them fail at both. Imagine Leo's perspective during a 2026 holiday season. While the child support payment ensures there are gifts under the tree, it cannot fill the chair at the dinner table. Leo observes the tension between his parents over the payment schedule and the visitation calendar. He begins to view family through a lens of litigation. This is the intergenerational cycle of the system. Leo grows up seeing the state as the ultimate arbiter of his relationships. He sees his mother as the manager of the funds and his father as the source of the funds. The qualitative, messy, beautiful reality of a father-son bond is replaced by a transactional agreement. Step by step, we see how this leads to the poverty of presence. Even in middle-class families where the child support is high, the child suffers from a lack of mentorship. In the year 2026, as the economy becomes increasingly complex and automated, the lack of a father's guidance on resilience, negotiation, and professional conduct is a massive disadvantage. Case studies suggest that the economic stability provided by a child support check does not compensate for the lost lifetime earnings that come from a lack of parental mentorship. Leo enters the workforce with less social capital because the system kept his father on the periphery of his daily life. Furthermore, we must address the impact on social institutions. The decline of the father's role has a direct historical link to the expansion of the state. As families fragmented under the weight of the 1975 Title IV enforcement model, the government stepped in to fill the gaps in childcare, education, and social services. In 2026, the American public pays billions for programs that are essentially trying to patch the holes left by marginalized fathers. If the system had prioritized shared parenting and fatherhood retention, the demand for many of these state-run safety nets might be significantly lower. The system creates the problem it then taxes the citizens to solve. The data on fatherlessness is often weaponized in political debates, but the historical trend is nonpartisan. Whether in rural communities or urban centers, the marginalization of the father is a primary predictor of future incarceration. This is the dark side of the debtor's prison cycle. When a father is jailed for contempt, as James was, the son learns that the state is more powerful than the family. In the year 2026, a young man like Leo is statistically more likely to enter the justice system if his father was incarcerated for child support debt. It is a cycle of state-sponsored abandonment that feeds the very institutions it claims to be protecting. We also see the effect on the next generation's view of marriage and commitment. Leo, seeing the struggle his father went through, may decide that the risk of fatherhood is simply too high. He sees a system that can take his license, his house, and his freedom if his income fluctuates. This leads to a historical trend of men withdrawing from the traditional family structure altogether, further accelerating the decline of the American birth rate. In 2026, we are looking at a society where the fear of the child support system has become a significant deterrent to starting a family. The generation of the void is not just a collection of individuals, it is a shift in the American character. When you remove the father from the equation, you remove a critical pillar of social order. The system's focus on the extraction of capital has ignored the qualitative importance of the father's presence. Leo represents millions of young adults who have all the material goods the child support system could provide, but who carry a deep systemic sense of loss. But what if there was another way? What if the United States isn't the only model for how a modern society handles the breakdown of a family? In the next part of our masterclass, we are going to look across the ocean. We will explore the international models for child support in custody that are producing better outcomes for fathers and children alike. We will dive into the Swedish and Nordic systems, looking at how they removed the adversarial conflict and replaced it with a focus on shared parenting and state-supported balance. You will see how other countries have managed to avoid the debt traps and the visitor status, and we will ask, why is the United States so far behind? The solutions are already being practiced elsewhere, and the next part will show you the blueprint for a system that actually works. To understand why the American system feels so uniquely punitive, we must look across the Atlantic to find a blueprint that operates on a completely different set of historical and philosophical assumptions. Imagine a father named Michael living in the United States in 2026, and his counterpart, a man named Eric living in Sweden. Both men have recently gone through a divorce and have 2 children. In the United States, Michael enters the Title IV machine we have been deconstructing. His income is scrutinized, his debt is non-dischargeable, and his relationship with his children is mediated by a visitor schedule designed to maximize the state's financial recovery. Now look at Eric. In the year 2026, Eric's experience is fundamentally different because the Swedish system was designed with a historical trend towards social cooperation rather than fiscal extraction. The first major difference is the concept of the state as a buffer. In the United States, if a father cannot pay, the mother and child often suffer immediately, or the state aggressively pursues the father to recoup welfare costs. In the Swedish under Hallstad system, the state acts as an intermediary. If a parent is unable to pay the full amount of support, the state pays a guaranteed minimum amount to the custodial parent. The state then works with the non-custodial parent to collect what is realistic. Crucially, the goal is not to drive the father into a cycle of debt. There is a protected level of income that the father is legally allowed to keep for his own subsistence, a level that is significantly more generous than the bare-bones exemptions found in most American states. Eric is never forced into a scenario where he must choose between paying child support and paying his own rent. The system acknowledges that a homeless or destitute father is of no use to his children. Step by step, the Swedish model prioritizes shared parenting as the default. While many American states in 2026 are still fighting over the rebuttable presumption of 50-50 custody, Sweden and other Nordic countries have made it the social and legal norm. This shift began in the 1970s and 80s, moving away from the tender years mindset decades before the US. Because the time is shared equally, the need for large transfers of cash is naturally diminished. Eric and his ex-spouse both provide housing, food, and clothing for the children during their respective times. The historical trend in these countries shows that when fathers are treated as equal parents from day one, their voluntary compliance with financial obligations skyrockets. They are not paying a fee to visit their children. They are directly providing for their children's lives. Data from 2026 indicates that in Sweden, nearly 50% of children of separated parents live in a shared residence arrangement. In contrast, the United States average hovers closer to 20 or 25%, with massive variations between states. This disparity is not due to a difference in paternal desire, but a difference in legal architecture. The U.S. system, as we've seen, is tied to Title IV federal incentives which reward the creation of a primary and non-custodial dynamic. The Swedish system has no such incentive. There is no federal bonus for a Swedish municipality to collect more from a father. The incentive is instead placed on minimizing conflict to reduce